Joining us now is Union Minister Shri Rajeev Chandrasekhar. Rajeev ji, namaste and Jai Hind. And it's a historic day for you and for a lot of people who've been eagerly waiting for the DPDP bill. Your first thoughts, sir? It's been tabled in Parliament.
No, I'm obviously, along with my colleagues in the ministry and indeed all of those who were participating in so many different rounds of consultations on the bill. I'm very happy that the cabinet has approved the bill and it is now introduced in Parliament. And I hope that we can see some good, positive debating and discussions around this bill that has been developed after a lot of consultation and a lot of thinking, and is certainly, in my humble opinion, a future-ready piece of legislation, a legislation that effectively protects the rights of Indian citizens and will put a brake to the exploitation and misuse of personal data that many platforms on the Indian internet today currently undertake. So I think it is something that we can all look forward to as being a very positive step for the orderly expansion of our digital economy and the protection of the rights of every Indian who is on the internet today and who is using the internet for business or pleasure.
There is walking the tightrope, then there is walking the tightrope without a balance pole, and then there is walking the tightrope on your toes without a balance pole. Somewhere this is what the DPDP bill does it endeavor to do. On the one hand, you're saying you want to protect the privacy and the interest of the digital Nagrik. Then you have the challenge of encouraging business, so ease of doing business, plus the larger challenge of governance and protection, data protection and security. So three difficult tasks. You think this bill has achieved that, sir?
No, I said this, I think, when we were doing the consultation and we had finalized the draft bill. I think this bill achieves what is seemingly, three very contradictory goals, but achieves all three of them in my opinion, in a very elegant, transparent and effective manner. One is, of course, to unambiguously protect the rights of digital Nagriks. The second is to do so without creating a cumbersome compliance burden for our startups and the innovation economy that is galloping and growing at a fast rate. So therefore, we certainly don't want to impede or slow down the expansion of our innovation economy. And the third is, of course, to create these exceptional cases and circumstances under which the government has the ability to lawfully use the personal data in cases of law and order, national security, emergencies like earthquakes and pandemics in a very transparent, laid out procedural manner. So I think all three of these objectives and goals, as befits one of the largest tech nations in the world, befits one of the largest connected democracies in the world, I think the Digital Personal Data Protection Bill achieves. And this has been achieved through the contribution of many hundreds and thousands of people who have participated in these deep, meaningful consultations that the government undertakes before these types of legislations are finalized.
But Rajeev ji, concerns remain when you say you want to encourage data privacy, but encrypted platforms then get misused. Just the other day, we've unearthed a story where the NCB itself has made a huge bust in the darknet, and it was platforms like Telegram, etc., that were being used, encrypted platforms to engage with entities who are operating in the darknet. So how do you draw the line? How do you draw the Lakshman Rekha? How do you ensure privacy but protect national interest?
No, so Anand, so we make it very clear that this is, as the Supreme Court has made it very clear, that this is a fundamental right, it's not an absolute right. And as you know, all fundamental rights have reasonable restrictions. And the reasonable restrictions here have been very well drafted to mean emergent situations like earthquakes, pandemics, law and order, national security, and or where a particular legislation requires a citizen to volunteer data. So it is very clear, it is very concise, there is no no case of the government having any unfettered powers, nor is there a case of the government having a separate threshold of accountability in terms of storage of data vis-a-vis the private sector, as was alluded to today in the morning when the bill was being introduced by some members of the opposition. And so I encourage every member, including citizens at large for whom this bill is really being drafted and enacted, that they should read this bill. It's a very, very simple legislation that does not require a law degree to understand or a lawyer to translate. It is a law that will read very well even for a normal citizen who is concerned about what his or her personal data is going to look like when he or she uses a platform or volunteers his or her data to a platform to avail of a service or a product.
Well, I was about to come to that, Rajeev ji. ये bill पढ़ेंगे तो समझ में आएगा. The last one ran into nearly 100 pages, had many chapters. So how simple or how easy is this one?
No, this is an extremely simple piece of legislation, and I think in a lot of ways we are setting the standard on the bar. The Prime Minister is very determined to achieve $1 trillion digital economy. He's very determined to continue the expansion of innovation driven by our young Indians. And he's also determined at the same time to create an overarching framework of laws and legislation that enable this growth, enable this innovation, and make it easy for even the citizens who are the direct beneficiaries of this legislation in terms of their personal data being protected, for them to be able to read and understand without having to have highly qualified lawyers interpret the law for them. I can certainly tell you that even for somebody like me who's a non-lawyer, this law and this bill makes a very simple reading, and I have circulated this legislation during consultation to many young students of law, many young students in colleges that are not lawyers, and all of them have responded very beautifully to the simple language and the very clear outcomes that the law attempts to build in its formulation and in its architecture.
Rajeev ji, 2-3 aspects we'll specifically focus on. One is for consent, because a lot of apps do not launch or do not apply, cannot be accessed till the time you give them consent, blanket consent. So you have to agree to all terms and conditions. You cannot selectively agree to some, and then, because they say then the app will not function. And then that too for how long? So is there a limit to rights that they will hold on data, information? Platforms that feed on pictures, posts, etc. So do they hold perennial rights? Does this bill actually address that issue?
Yes, the bill, Anand, is built around 5 or 6 basic fundamental principles. One of that is data minimization, which is that a platform can't go hunting for data from an individual. They can only seek the data that is absolutely required, the basic minimum required to deliver the service. So if I'm ordering some food on a food app, certainly the app has no business asking me for anything other than my address and my credit card details, who my father is, who my uncle is, my blood group, etc. Certainly beyond the scope. So data minimization. Purpose limitation is the second principle, which is that the data that you take from a citizen can only be used for the purpose that you have got the consent for. So there cannot be any misuse of the data, there cannot be any use of the data for something other than what the citizen has consented to. Then there is the whole issue of storage limitation, that the data cannot be kept by the platform and then used and misused again beyond the duration that it is required to be kept for delivering the service. So there are these broad principles that create fetters around every company that deals with Indian citizens' personal data, and I think it brings a lot of discipline, puts a brake on the whole phenomenon of misuse, puts a brake on the whole phenomenon of exploitation of personal data almost irreversibly and irrevocably when this bill is enacted.
One of the concerns was redressal and also the party, guilty party, the aspect of criminality. So is there going to be a criminal aspect to it, or is there just going to be a punitive financial angle to it? What's been decided?
There is, the formulation in this bill is that there should be punitive financial penalties that are so big and so significant that it causes big incentives, deep incentives for the platforms to behave themselves and to comply with law. Just to give you an example, if a platform today has 10,000 people on the platform and breaches 10,000 pieces of personal data belonging to 10,000 people, technically, theoretically, under the law, the Data Protection Board could levy a penalty of 10,000 times 250 crores. That is, as you would imagine, it's a lot of money, and it's certainly something that will make platforms behave themselves very well, because the whole idea of the penalties is that it is not a small slap on the wrist, it's a significant punitive way to dissuade them from ever having to breach this law or violate the obligations they have to any Indian citizen with whom they are dealing with, whose personal data they are dealing with.
Rajeevji, where will the redressal happen? Is there going to be a separate board? What will be the contours of this board?
Yes,
who will
there
be
is
sitting
going
on
to
this
be
board?
the bill.
And
the
will
bill
it be
has
autonomous,
proposed,
constitutional,
yeah,
or under the court?
The bill envisages the Data Protection Board, and it has been very carefully designed as an independent board, independent from the government, and where every decision of the Data Protection Board, every adjudication of every data breach can be appealed to a tribunal, the TDSAT, which in turn can be then appealed to the High Courts. So there will be multiple levels of oversight on the performance and the efficacy and the transparency that is required in the functioning of the Data Protection Board. The Data Protection Board will be independent of the government. It will have people of capability and capacity to deal with these kind of breaches and these kind of adjudications and disputes between those who are victims of the breach and the breach creator. And there is multiple levels of oversight about the Data Protection Board that should give confidence that the institution of the Data Protection Board over time will develop into a mature and accountable institution that is accountable for the stakeholders of the data economy at large.
One more question is about children. Data of children, images of children, and also data that children could be exposed to. Is there something that was going to govern all these aspects, including child pornography?
Oh, absolutely. I mean, obviously, child pornography is not the subject matter of this bill. This bill relates to personal data. And we have made it very clear that all platforms have to seek parental consent before they can get personal data of children below the age of 18. The age gating, that's the phrase for this, is 18 in this legislation. But we have created a framework of incentives. That is, if a platform demonstrates that it is an extremely safe place for children, and based on criteria that the NCPCR and other bodies will help the Government of India frame, then there is a possibility down the road over the next few years that certain platforms can have the age based on their demonstration that they are a very, very safe zone for children and children personal data, and they can effectively, they demonstrated a track record of handling personal data of children with utmost responsibility and safety and care, that the age of consent could be notified for those special cases as a different age. But as a basic construct,
right,
below the age of 18, any personal data that is sought by any platform needs parental consent, and that is built into this law.
Is the aspect of data sovereignty also addressed? How much of India's data or national data is going to be protected? Because this is all Indian citizens. And will the government have access to this data?
The whole concept of the processing of that data outside of India is built on the premise that data will be allowed to be processed in any geography where the Digital Personal Data Protection Bill will be applicable, its jurisdiction will apply, and the rights of the Indian citizens derived from the DPDP will be applicable. So we have not created a white list. As a matter of fact, the whole premise and the construct is that as we go down the road and see that there are certain geographies and countries that do not align themselves or harmonize themselves with the DPDP provisions and the rights for the Indian citizens, we will start creating a blacklist of countries where the data protection bill does not apply, and therefore data processing and of personal data will not be permitted. So that is the basic premise. And the broader issue of data sovereignty, Anand, as I have discussed with you earlier, will be dealt with under the Digital India Act, because the data sovereignty deals with personal data and non-personal data, and that is something that is being actively discussed in the context of the Digital India Act.
So when are we going to see the Digital India Act? One part of the last question, the other part is how much of unbridled access is the government allowed in the DPDP,
Anand,
or are there some are there some blocks there too, and restrictions on the government?
Digital personal data protection. No, sorry, Anand, I'm sorry. There's a crosstalk, but the Digital Personal Data Protection Bill is a comprehensive legislation that deals with all of the rights of Indian citizens vis-a-vis their personal data and all of the corresponding obligations of any platform, any data fiduciary company that deals with Indian citizens and deals with the personal data of Indian citizens. So this is a comprehensive legislation, and any other legislation that comes down the road will deal with other aspects of data, including non-personal data, anonymized data, data standards, etc., etc. But insofar as the personal data of Indian citizens is concerned, insofar as protecting the personal data of Indian citizens is concerned, this bill is a comprehensive, future-ready legislation that will certainly will transform and create deep behavioral changes amongst the companies and platforms that deal with Indian citizens' personal data.
The government access unbridled, or are there limitations to that and conditions to that too?
No, they're very restricted. There are two issues that have been raised in Parliament today. Both of them, regrettably, are mischaracterizations and wrong. One is that the government has a different threshold of liability in the event of a breach. That is incorrect. Insofar as this being a fundamental right and there are restrictions to the fundamental right, the government has, in the event of law and order, national security restrictions, national security conditions, the ability and the lawful right to access personal data. Emergencies like earthquakes and pandemics, where certainly government cannot be going around looking for a consent from a citizen before it uses the personal data, blood group, etc., etc. Those are also exemptions that have been given to the government. These are very reasonable. These are absolutely consistent with what most governments seek around the world in this overall ecosystem. And again, the characterization that it is unbridled, it is unfettered, is respectfully, wrong.
Rajeev Chandrasekhar ji, thank you very much, and congratulations on getting the DPDP bill into fruition and into Parliament. Whether or not it gets the nod of the House we'll have to wait and watch. But thank you for your time, and thank you for explaining the contours of the DPDP bill.
Thank you.
Thank you, sir.